Reasons that follow the relief requested by the defendant, including an evidentiary hearing, are unnecessary. The background. On or about September 16, 2024, the defendant was arrested. The following day, the above-referenced indictment was unsealed, and the defendant was presented and arraigned before the Honorable Robin F. Tarnofsky, United States Magistrate Judge. As part of that proceeding, the government moved for detention under the Bail Reform Act. Finding that there was no condition or a combination of conditions that would assure the safety of the community, Judge Tarnofsky denied the defendant bail. The following day, the Honorable Andrew L. Carter heard the defendant's bail appeal, and after a lengthy hearing determined that the government had proven by clear Ariel Mitchell Kidd and Stephen A. Metcalf on Wednesday requested to withdraw as her legal counsel in a court filing obtained by USA Today. They cite a breakdown in the attorney-client relationship and irreconcilable differences as the basis for parting ways with their client. So there has to be something going on behind the scenes as far as what Adria English is telling them, or how she's behaving, or how her lawyers are perceiving she's behaving. And this is not something that's uncommon. You'll have lawyers that have clients, and sometimes things just don't jive. So they'll request that they get removed from the case. And a lot of times the judge obviously will okay that request. He'll sign off on it as long as it's not going to, endanger the trial or something like that. And considering this is so new, I don't think that there's going to be an issue from the court when it comes to these lawyers deciding not to take Adria English's case. As a result of fundamental disagreement between the attorneys and English regarding almost every aspect of the litigation, including settlement demands, causes of actions in the pleadings, as well as English's alleged undermining behavior and questionable antics, the attorneys say irreconcilable conflict and tension has developed, the motion reads. So that's not looking good for Adria English, right? When you're dealing with somebody like Diddy and he has a legal team like he has, they're going to latch on to something like this and they're going to use it to their benefit. Oh, look, she can't even get along with her own lawyers. She's obviously telling, stories. She's not being truthful. She's a liar, basically, is what they're going to say. And anything that demeans your credibility when you're going through something like this could really prove burdensome. And that might be where Adria English is at. And like I said from the beginning, just because people make allegations doesn't mean that all of the allegations are true. And I'm not saying that what Miss English said isn't true. We don't know yet. But there's obviously some kind of problem here, some kind of animosity between her and her own lawyers. So it doesn't look good, right? The optics, they don't look very good. The withdrawal is a result of English allegedly breaching a September 24th agreement they entered into due to her tone and lack of respect and continued behavior and self-destructive activities, the attorneys claim. I'm not going to read too much into that, but we can pretty much speculate what they mean. Self-destructive activities, drugs, the rest of it. That's probably what they're talking about. And they don't want to deal with a client who isn't completely there. If somebody's on drugs, they're unreliable, they're unpredictable. And when you're dealing with a case like this, that's the last thing you need from your clients or your witnesses. You need people to get up there that are clear-headed, that are going to get on the stand, and they're going to recount the abuse that they suffered at the hands of their alleged abuser, and in this case, that's Diddy. And it's looking like the lawyers for Adria English, or former lawyers, they don't feel like that's going to be able to occur with her. And it looks like they took some steps to mitigate that, with this agreement, the whole thing, and according to them, Miss English hasn't lived up to her end of the bargain. And if you think that Diddy's team won't use this against her in some court filings moving forward, they most certainly will. The lawyers in the filing asked to speak with the judge in a private conference about the specifics of their request and note that English has sought out new representation. They also mentioned Combs' team has not been served with the complaint, which was initially filed July 3rd and refiled September 17th. So this whole entire thing is just a gigantic ball of issues for Adria English. The suit wasn't even served yet? What does that even mean? Obviously, it's in everybody's best interest if Miss English gets different legal representation, and that looks like the path that we're certainly on. USA Today has reached out to Mitchell Kidd and English for comment. Mitchell Kidd told the New York Times on Thursday that she never lost faith in her case, just in her, adding, "Her case is great. My issue was with her undermining my work and going behind my back and doing things incongruent to advancing her case." English told The Times she clashed with Mitchell Kidd on issues, including the attorney telling her not to speak with the media. That's sound advice. If you have a legal case pending, probably not a good idea to get in front of the media and talk about it. Not if you want to win your case, right? So it seems to me that Ms. Mitchell Kidd was giving her sound advice. However, when you're in the situation that Ms. English is in, she might feel like she has to get out in front of this and bring her story to the people directly. And I understand what she's going for there. It's not a bad strategy. But once you have legal representation and your case is cooking inside of the courtroom, you got to take a step back and let that whole entire process play out. In a statement shared with USA Today, a spokesperson for Combs claimed English made completely fabricated statements. In papers filed with the court today, her former attorney cited Miss English questionable antics and undermining behavior. As we said from the start, anyone can file a lawsuit without proof, and this case is a clear example of that. The statement continues, Adria English escalated things by filing false police reports and making baseless claims, using high-profile events as a backdrop to harm innocent people. No matter how many lawsuits are filed, it won't change the fact that Mr. Combs has never sexually assaulted or sex trafficked anyone. And as you can see here, Diddy's team's already latched onto this to launch an attack at Adria English's credibility. And that's why her former lawyer didn't want her talking to the press. Because no matter how you chop it, Diddy's team, his legal team, is very competent. And any missteps that are made along the way, they're going to be able to harness and use for their own benefit. Combs, who was arrested on September 16th and arraigned on sex trafficking, racketeering, and transportation to engage in prostitution charges the following day, has been incarcerated in the Special Housing Unit at Brooklyn's Metropolitan Detention Center. He's maintained his innocence amid an avalanche of civil lawsuits over the past year and pleaded not guilty to all charges. In her 114-page lawsuit filed in U.S. court for the Southern District of New York, English alleged that she was sex trafficked by Combs and his associates between 2004 and 2009 in New York and Florida. A New York go-go dancer at the time, English claimed that she agreed to work as entertainment at Combs' white parties in the Hamptons and Miami to help her boyfriend secure modeling work with Combs' fashion brand Sean John. She alleged that she was forced to drink copious amounts of alcohol and consume illicit narcotics, including ecstasy, and eventually was coerced into having sexual intercourse with guests. English also accused Combs of helping her break into the music industry, to silence her and keep her in his sex trafficking organization, as well as threatening to harm or blackball those who did not comply with his demands. And all of that is part of a common theme that we've seen with Diddy throughout this whole entire thing. Seems like everybody who comes out with allegations has the same exact thing to say. After nearly a dozen civil lawsuits over the past year accused Combs of sexually assaulting and trafficking alleged victims, last month federal prosecutors announced a bombshell federal grand jury indictment that revealed an extensive and ongoing federal investigation into the hip-hop icon. And there was no doubt that this was all coming. It was just a matter of when. When the feds raid your house the way they did Diddy's, and they have such an extensive investigation going on, chances are you're going to be charged with something, and you're going to end up getting arrested. And that's where we find ourselves now. After all of that investigation, after raiding Diddy's properties and collecting all that evidence, using that evidence to corroborate statements given to them by witnesses, they were at the point where they said, you know what, we have enough, it's time to go. And that's when they arrested Diddy. Now the question is the evidence that they collected going to be enough to get the conviction that they're seeking? And I guess that's where we're at right now, right? Trying to figure out the forest through the trees. But whenever you have this many people coming out and the kind of evidence that we've seen already, it's certainly not looking good for old Diddler. Investigators say the 54-year-old elaborately schemed to use his finances and status in the entertainment industry to fulfill sexual desires in a recurrent and widely known pattern of abuse. Investigators have taken in more than 90 cell phones, laptops, cloud storage accounts, as well as at least 30 storage devices. They issued more than 300 grand jury subpoenas to obtain this evidence from communications providers, tech and social media companies, financial institutions, and Combs companies. Prosecutors say that they have dozens of videos depicting Combs' so-called freak-offs, sometimes days-long sex performances between sex workers and people he allegedly coerced into participating through narcotics and intimidation that corroborate witness testimony. So when you have that kind of evidence staring at you in the face, you're in big trouble. And as far as Adria English goes, I'm sure she'll find new representation, there's no doubt about it, but the optics aren't good. Now, does that mean she's not telling the truth? Of course not. But the optics certainly aren't good. And if you give Diddy's team even one single foot, they're going to turn it into 10 miles. And that's what I expect them to do when it comes to Adria English and her allegations. So we'll have to see what the strategy is going to be for Diddy's team, but they've already signaled that they're going to try and destroy the credibility of the accusers. And from the past experiences we've had with R. Kelly, with Keith Raniere, with Ghislaine Maxwell, that doesn't seem to be a winning formula. But we'll see what they come up with, and we'll be here every step of the way as they formulate the plan. But that's going to do it for this one. In this episode, we're going to dive right back into those court documents, and we're going to take a look at the Memorandum of Law in Support of Motion to Withdraw as Counsel of Record that was filed by Ariel Mitchell Kidd when it comes to her representation of Adria English. Case number 24-CV-05090-AT. Adria English, Vershawn Combs, etc. Memorandum of Law in Support of Motion to Withdraw as Counsel of Record. The Law Office of Ariel Mitchell, PA, Ariel Mitchell Kidd, ESQ, Metcalf, and Stephen Metcalf II, collectively attorneys, respectfully submit this Memorandum of Law in support of its motion, pursuant to Local Civil Rule 1.4, to withdraw as Counsel of Record for Plaintiff Adria English. Preliminary Statement. Attorneys respectfully moves the court to withdraw them as counsel for plaintiff at this early phase of this case, based on numerous satisfactory reasons for withdrawal under Local Civil Rule 1.4. First, the plaintiff has provided conflicting instructions that make it unreasonably difficult for attorneys to effectively represent the plaintiff. Second, there has been a breakdown in the attorney-client relationship between attorneys and the plaintiff. Third, there are irreconcilable differences with attorneys and plaintiff. And fourth, plaintiff violated an agreement between plaintiff and counsel signed on Tuesday, September 24th, 2024, on Thursday, September 26th, 2024. Under these circumstances, it's impossible for attorneys to serve as the plaintiff's counsel in this case. It bears emphasis that attorneys' withdrawal as plaintiff's counsel will cause no prejudice. This case is in its infancy, and defendants have not even been served plaintiff's complaint. The court recently ordered that the plaintiff file its joint letter and proposed case management plan by October 1st, 2024. Undersigned counsel has filed a motion for extension of time regarding the case management plan, and additionally, attorneys are requesting an ex parte conference with the court to discuss the basis which has caused attorneys' withdrawal. Attorneys are asserting a retaining and/or charging lien against plaintiff in connection with the case. If it should continue to court to recover all unpaid quantum merit fees and expenses owed attorneys, including fees and costs plaintiff owes to attorneys for services provided in connection with the case and other matters. Accordingly, attorneys respectfully request that the court enter an order relieving attorneys as counsel for plaintiff. The statement of facts. The facts relevant to this motion are set forth in the accompanying declaration of Ariel Mitchell Kidd and Stephen Metcalf. Argument. Local Civil Rule 1.4 provides in full as follows. An attorney who has appeared as attorney of record for a party may be relieved or displaced only by order of the court and may not withdraw from the case without leave of the court granted by order. Such an order may be granted only upon a showing by affidavit or otherwise of satisfactory reasons for withdrawal or displacement, and the posture of the case, including its position, if any, on the calendar, and whether or not the attorney is asserting a retaining or charging lien. All applications to withdraw must be served upon the client, and unless excused by the court, upon all other parties. When considering whether to grant a motion to be relieved as counsel, district courts analyze two factors. the reasons for withdrawal, and the impact of the withdrawal on the timing of the proceeding. Tough America Incorporated vs. Codigo Music, LLC, number 11, CIV 1434 ER, 2017 WL, 3475499 at 5 SDNY, August 11th, 2017. There are 4 independent and satisfactory reasons to grant attorney's request to withdraw as a plaintiff's counsel. An attorney's request to withdraw is based on 4 independent grounds, each of which constitutes a satisfactory reason for a motion for withdrawal under Local Civil Rule 1.4. A. First, the plaintiffs have provided conflicting instructions that make it unreasonably difficult for attorneys to effectively represent the plaintiff. A lawyer may also seek to withdraw from a case when the client renders it unreasonably difficult for the lawyer to carry out such employment effectively. Farmer v. Hide Your Eyes Optical Incorporated 60 F.SUPP 3D 441 445 SDNY 2014. Accord Ramguli v. Ramguli number 16-CV-3345 VEC SN 2020 WL 883-8048 at 1 SDNY June 24, 2020. Here, that is precisely what has happened because plaintiff has provided attorneys conflicting instructions. To protect attorney-client privilege, we will not go into detail here as to the ever-evolving and conflicting demands that plaintiff has made of attorneys as it pertains to the claims raised in this case, as well as what attorneys were instructed to relay to defendants and other third parties. Accordingly, this is another independent and satisfactory reason to grant attorney's motion to withdraw as plaintiff's counsel. B. Second, there has been a breakdown in the attorney-client relationship between attorneys and the plaintiff. There has also been a breakdown of the attorney-client relationship between attorneys and plaintiff because plaintiff has provided attorneys conflicting instructions and there are irreconcilable differences between attorneys and the plaintiff. This constitutes a satisfactory reason for withdrawal under Local Rule of Civil 1.4 C. Nicanovo v. Flirt NY Incorporated, number 1 19-CV-07-128 SDA, 2021 WL 419-8231 at 2, SDNY September 14th, 2021. Satisfactory reasons for withdrawal include, for example, an acrimonious relationship developing between the law firm and the plaintiff. See also Amoruso v. City of New York, number 15-CV-03381 RA BCM 2016 WL 1697602 at 2, SDNY April 27th, 2016. A deterioration in the attorney-client relationship can provide adequate ground for withdrawal even where the client objects. Accordingly, the court must grant the attorney's motion to withdraw as plaintiff's counsel. C. Third, there are irreconcilable differences with the plaintiff. Under Rule 1.1, 6, C4 of the New York State Rules of Professional Conduct, a lawyer may withdraw from representation where the client insists upon taking action with which the lawyer has a fundamental disagreement. Furthermore, under Rule 1.16c7, the lawyer may withdraw where the client fails to cooperate in the representation or otherwise renders the representation unreasonably difficult for the lawyer to carry out employment effectively. The existence of an irreconcilable conflict between attorney and client is a proper basis for the attorney to cease representing his client. Bajam, Karaman v. Time Equities Incorporated, number 10, CIV 3773 2011, U.S. District Lexicon 519-16 at 4, 5 SDNY, May 11, 2011. Permitting withdrawal on the grounds that strong evidence of a strained attorney-client relationship, regardless of the source of the strain, is sufficient grounds for an attorney to withdraw. McGuire v. Wilson, 735F.SUPP 8385, SDNY 1990. Allowing attorney to withdraw because relationship between the parties has deteriorated beyond repair. Hallmark Capital Corporation v. Red Rose Collection, number 1997, U.S. District Lexicon 16328 at 8-9, SDNY October 21st, 1997. The client and the counsel have irreconcilable differences. That is a satisfactory reason to allow counsel to withdraw. Withdrawal has been permitted where an irreconcilable conflict developed between counsel and client regarding litigation strategy. Hallmark Capital Corporation 1997 U.S. District Lexus 16328 quoting Tufano v. City of New York, number 94 CIV 8655 1996 WL 419912 at 1 SDNY July 25th 1996, citing San Severio v. Sanders 117 AD 2D 794 795 499 NY 2D 431 431 Second Department, motion to withdraw granted in light of the irreconcilable differences between counsel and his client with respect to the proper course to be pursued by counsel in the litigation. See also Casper v. Liu, Lieberbaum and Company, 1999, U.S. District 7779 SDNY, May 24th, 1999, permitting withdrawal where plaintiff and original counsel disagreed about litigation strategy, the value of the case, and the strength of the case. Furthermore, counsel ethically can withdraw where the client insists upon a course of conduct that is contrary to the judgment and advice of counsel. As a result of a fundamental disagreement between attorneys and plaintiff regarding almost every aspect of the litigation, including settlement demands, causes of action in the pleadings, and plaintiff's undermining behavior and questionable antics, an irreconcilable conflict and tension has developed between plaintiff and attorneys. Recent communications with plaintiff in particular were heated and contentious and was emblematic of previous conflicts between plaintiff and attorneys where plaintiff was warned about her tone and lack of respect. This made it clear that there had been significant erosion of the attorney-client relationship. Plaintiff and attorneys have extremely diverging and irreconcilable views with respect to the appropriate strategy to employ in this litigation and the resources which must be devoted in prosecuting this lawsuit. Accordingly, plaintiff's destructive and undermining actions have seriously impaired attorney's ability to represent her. Fourth, plaintiff violated an agreement between plaintiff and counsel signed on Tuesday, September 24th, 2024, on Thursday, September 26, 2024. After being warned several times by attorneys about plaintiff's tone and the lack of respect in plaintiff's continued behavior and self-destructive activities, attorneys tried to mitigate further damage plaintiff was causing her case and herself. Attorneys and plaintiff, therefore, entered into a separate agreement on September 24th, 2024, in an attempt to prevent plaintiff from continuously undermining attorneys' efforts and her overall case. Plaintiff subsequently breached that agreement on September 26, 2024, thereby forcing attorneys to have no other choice but to withdraw. It should be noted that even after breaching the agreement and being told attorneys would no longer represent plaintiff due to the breach, plaintiff continued to text attorneys as if nothing had happened. Attorneys were recently contacted by another law firm who plaintiff contacted for representation after plaintiff violated the agreement on September 26, 2024, causing attorneys withdrawal and therefore should not object and or protest to the courts the withdrawal of attorneys as counsel of record. C. Withdrawal of counsel will not prejudice plaintiffs. Plaintiffs will not be prejudiced by attorneys' withdrawal as counsel. There are currently pending deadlines and dockets of October 1st, which have been requested by motion to be extended if the court believes this case should continue after attorneys have the opportunity to have an ex parte hearing with the court. Further, plaintiff has sought new counsel who is deciding on whether or not they will continue with the case given the court's decision after the ex parte hearing. Conclusion. In an effort not to prejudice plaintiff, attorneys have intentionally left out key details and examples of plaintiff's actions which led to attorney's decision to withdraw as counsel. Attorneys believe the court must hear these details and hereby respectfully request that the court hold an ex parte hearing so the attorneys may share the undisclosed details off the record. For the foregoing reasons, attorneys from the law firm of Ariel Mitchell, PA, and Metcalf & Metcalf, Ariel Mitchell Kidd, and Stephen Metcalf II, respectfully request that the court grant their motion to withdraw as counsel of record for plaintiff. This document was signed on October 1st, 2024, and it was signed by Ariel Mitchell. All of the information that goes with this episode can be found in the description box.